And we have everybody, so I will call our meeting to order. Welcome to the April 15th, 2025 meeting of the Planning Board. First, we'll take a roll call to introduce board members and staff. Kate Nee.
Here.
Phil Giordano.
I'm here.
Josh Ames.
Here.
And Sean Weller.
Here.
We are also joined by Elijah Romulus, our town planner, Nora Locknane, our Director of Community and Economic Development, and Jack Hatfield from Westwood Media Center. This meeting is recorded by Westwood Media Center and broadcast live on local cable television Comcast Channel 6 and Verizon Channel 42. Meetings are also live on the Westwood Media Center's YouTube channel. If you're interested in joining the meeting via Zoom, you can find the login directions in the Planning Board meeting notice that is posted to the calendar section of the town's webpage at https://www.townhall.westwood.ma.us/. We will begin the meeting with only the board members and staff unmuted and on video. As the chair recognizes individuals to speak, we will unmute them. Board members may choose to mute themselves when they are not speaking in order to minimize background noise. For applications, the chair will first invite the applicant to address the board and give a presentation summarizing what is being requested. Board members received the application materials prior to the meeting and will have reviewed them. Board members may ask questions during and following the presentation. Staff and outside experts will provide comments to the board. For agenda items that are not a public hearing, the opportunity for public comment will be at the discretion of the board chair. For agenda items that are for a public hearing, the public will be given an opportunity to comment after board discussion. Public comment will only be read or heard once the chair has opened the public comment period. The chair will ask for any final public comments before closing public comment. During public comment, attendees may use the raise hand feature to speak or type a question in the Q&A at the bottom of your screen. Attendees will not be on video, but will be unmuted if called on during the public comment portion. To raise your hand, click on the raise hand icon at the bottom of the screen and wait for the host to call on and unmute you. You may then click lower hand once you've been called on. For those participating by phone, you can raise your hand by pressing *9. Once unmuted, please identify yourself by stating your name and address for the record. Please direct all comments and questions through the chair and only have one person speaking at a time. Those making public comment will have 3 minutes to speak. All people will be given the opportunity to speak, but in the interest of time and fairness, repetitive or off-topic comments may be limited. Additionally, comments may be submitted by email or regular mail prior to the meeting. When we come to that part of the meeting, I will remind everyone of the process. Following the public comment portion, the board will deliberate and make a decision or continue the hearing to a specific future date. All remote meetings require that votes be taken by roll call. When a motion and second has been made, the chair will ask if there's any further discussion before proceeding to a roll call vote and will then restate the results of the vote. Okay. We've also been joined by Jess Cole, our recording secretary. Hi, Phil, yes.
Madam Chair, I just wanted to give everyone a heads up. I have a hard stop at 8:30 because I do have to go to the airport. So I don't want to cut off discussion, but I do want to just give everyone a heads up that I do have to leave at 8:30. So that's kind of my limit. Thank you.
Thank you. Thank you. That is good guidance. Elijah, yes.
Madam Chair, I just want to reiterate the announcement that you made earlier, that anyone looking to join the meeting will need to go to the actual public meeting notice to join via the link.
Thank you. All right. It looks like, sorry, I saw a panelist hand up. That was you. All right. So, Elijah, any changes to our agenda this evening?
No changes.
All right. With that, then I will, if I can find the hearing notice, I will open the public hearing for our agenda item this evening by reading part of the public hearing agenda notice. Notice of public hearing pursuant to Chapter 20 of the Acts of 2020. Oh, no, sorry. The Westwood Planning Board will hold a remote public hearing in accordance with provisions of MGL Chapter 40A, Section 5, on Tuesday, April 15th, 2025 at 7 p.m. via Zoom to consider the following proposed amendments to the Town of Westwood Zoning Bylaw. The meeting will be filmed live by Westwood Media Center, WMC, available for viewing on Comcast Channel 6, Verizon Channel 42, I've stated all of that in my opening remarks. The articles are as follows. Article SB-11, zoning bylaw amendments relative to municipal public safety facilities. Article SB-12, zoning bylaw amendments relative to flood area overlay district, FAOD. And the final article, Article SB-13, zoning bylaw amendments relative to assisted living residences and nursing or convalescent homes. And it looks like we are joined by the select board. Welcome all. And also it looks like Molly. Joe, do you need to call your meeting to order?
Please, may I?
Absolutely.
Okay, pursuant to Chapter 2 of the Acts, seeing we have a full attendance, Acts of 2023 amended on March 25th, 2025, Governor Maura Healey signed into law an act extending pandemic-related authorizations related to public meetings, allowing remote meeting options for public bodies through June 30th, 2027. April 15th, 2025, Select Board will be conducted via remote participation by the board. The chair grants permission to Westwood Media to record the meeting and to anyone else who would like to do so. And without further ado, would you like to get started on the zoning bylaw amendment, Ellen? May I start with the presentation?
Yes, absolutely. Oh, and we're also joined by Dan Bailey. Sorry, Attorney Bailey. I did not see you come in. All right. Yes, please. You have the floor. Happy to see your presentation. Thank you.
All right, Elijah, let's hop to the next one, please. So we would like to go over, Mary Ann, Rob, and I'd like to go over the key challenges of the Fire Station 1 project, the zoning overview, appeal, financial implications, and proposed bylaw amendment. And Rob, I think you're taking the next few slides. Is that correct?
That's right, Joe. Thank you.
Yeah.
Hello, everyone. Thank you for having us again tonight. You all have seen this presentation, at least some pieces of it, several times, so you may be familiar with some of the challenges in designing this facility. Certainly the size of the building and its location were two factors. We've spent a lot of time going over all of that with you, so I'm going to summarize that here. Obviously, FS1 is a unique building here in town. No other building, whether private, commercial, residential, has to accommodate the large emergency response apparatus that is housed at FS1, the living quarters for 24-hour co-ed shifts, hot and cold zones from a contamination standpoint, training facilities and administrative offices. All of that is what drives the size of this building. The second floor is where the living quarters are. That is all of the sort of orange area that you see. The green zone is the training space, and the red area is the administrative space.
Next slide, Elijah, please.
Oh, I'm sorry.
No, you're good. You're good.
Yeah, thank you, Joe.
Yep.
I'm looking at it on my screen, but I forgot to give Elijah the cue. So Elijah,
I'm with you. I'm with you. No problem.
Yeah. All right. If you would, so again, yellow space, living space, green space, training space, red space, administrative space. Next slide, please. As you know, we looked at, the location of the facility to minimize response time to some of the hottest zones that we have in town in terms of response call for service. So the feasibility study confirmed that maintaining the existing facility around High Street was essential to do that. And within the design zone, there were very few parcels of land that can accommodate our programmatic needs while adhering to our zoning regulations. So when we made the decision on where this main station should be located, access onto High Street was of critical importance given response time. And so we considered all of the various options and landed, as you know, at new construction on the existing site as the most cost-effective way to provide the public safety service that the community needs and deserves. So Joe, I believe this one is you.
Yes. Thank you, Rob. Good job. Our working group was tasked with designing a facility that met the operational needs of the fire department and in the future. Is located on town-owned land and complies with Westwood zoning bylaws. As discussed, due to limited available sites, as Rob mentioned, we found the High Street site the best site as far as operational readiness. Next slide, please. Why do we have the zoning bylaw? In order to have orderly development, public health and safety, property value protection, infrastructure and resource planning, environmental protection, economic development, and community and character and aesthetics. The orderly development ensures different land use, residential, commercial, industrial, and appropriate areas. The public health and safety prevents
Excuse me, Joe. Yeah, I'm sorry. Elijah, would you go back one slide? Thank you.
Yes.
Thanks, Rob. Property value protection prevents incompatible developments next to each other. Infrastructure and resource helps municipalities manage roads, utilities, and public services. And lastly, preserves wetlands, floodplains, and other resource areas. Next slide, please. Zoning variant. Thank you. Thanks, Elijah. Zoning variance allows property owners to deviate from zoning regulations in cases where strict enforcement would create unnecessary hardship or prevent reasonable land use. The existing site conditions create significant challenges for zoning compliance. While many municipal projects have historically sought and received variances, the variances required and to move forward FS1 are presented unique challenges. And as a homeowner myself, I also had to seek a zoning variance. So it's not something that's unusual. And the zoning board's very understanding. Next slide, please. The town presented in its process to the Finance Board, the Conservation Commission, the Zoning Board of Appeals in fall of 2024. These boards held numerous public meetings allowing extensive community feedback and careful review of the project's design, environmental impact, and zoning regulations. These boards conducted a comprehensive and transparent process during which they examined all aspects of the FS1 project, including safety considerations, environmental impact, and adherence to the town's long-term planning goals. The deliberations resulted in a meaningful design modifications to address the concerns that were raised by residents and abutters and ensure that the project meets high standards of quality and community appropriateness. Following the rigorous evaluations, each board unanimously approved FS1 project, including required variances. Next slide, please. Marianne, I think you're up.
Yes, I am. Thank you, Joe. Good evening, everyone. Thank you for having us. I'd like to talk a little bit about the appeal now. As you just heard, and as you are all fully aware, the FS1 project was fully vetted and unanimously approved by the Planning Board, the Conservation Commission, and the Zoning Board of Appeals. And as this board will remember, you placed an order of, I believe, 27 conditions on this project. And you are also aware that a number of steps have been taken along the way in this process to mitigate impact on the neighboring neighborhood, particularly as to light, sound, screening, stormwater management, and even traffic issues at the top of Windsor Road. That said, an appeal of the ZBA decision as to the 7 variances was filed by 23 residents. And while that mediation is at a standstill, we are still actively trying to resolve that matter. However, that legal appeal does threaten to stall progress on what is an urgent public safety project, which raises concerns about the safety of our residents and the safety of our firefighters. It raises concerns about cost escalations due to construction delays and therefore increased burden on our taxpayers. To be clear, the article that we bring before you tonight is not our preferred option. But as we have recognized repeatedly for the past 1.5 years, this is now an urgent public safety need. And so to ensure that the town has the ability to finally get this project done, if town meeting so votes at town meeting on May 19th, this zoning exemption article has been brought forth. Next slide, please. So what would be the impact of a scaled down facility that meets existing zoning regulations? Have we contemplated shrinking the building? And as you on this board, on the planning board, are well aware, the size of this building has been discussed at great length. If we were to eliminate a bay, and of course the size of the station is driven by the number of bays increasing from 4 to 5, if we were to eliminate a bay, the building will not be large enough to house the equipment that it needs to provide life-saving measures to the community, and will not have that apparatus in the mission-ready position to reduce response times, which is critical to public safety. Were any other sites, including privately owned parcels, considered? As we discussed, land is at a premium in the area the building needs to be built, and we did reach out to abutters, but were not able to purchase any abutting land due to lack of interest. The same was true as to the potential for an easement on an abutting property. The owners were not interested. As presented to the town by the abutters, their main concern appears to be the potential increase of vehicles in the neighborhood caused by the elimination of the fire department's driveway. The increased number of staff using Hillcrest Place, which is the road directly behind the fire station, on a daily basis would be in the single digits, if any, with the new building, and the increased number of apparatus coming in for service via Hillcrest from FS2 is approximated based on service records of the past 24 months at 2.3 vehicles per month. That is to be balanced against the fact that now some apparatus respond to emergency calls only from the rear of the building through Hillcrest Place to Windsor Road to High Street, and need to exit through the neighborhood with lights on during emergency calls. That includes Engine 1, Ambulance 3, and the Kubota. With the new station, there will be no planned response for apparatus responding to emergencies from the rear and through the neighborhood. The impact of the new station on traffic in the neighborhood will be incremental at best, and may even, in light of what I just said, be a net positive. I will now turn this to Rob.
Thank you, Mary Ann. And as you heard Mary Ann talk about, we have tried to work with the abutters to get to a resolution through mediation, and we still hope to do so, but hope is not a strategy. So, when you think about, Elijah, if you would change the slide, please. What happens if we don't move this project forward? There's a real possibility that the building could be either deemed unsafe or even condemned for working conditions. And there are 4 main areas of concern that you saw throughout the presentations that I'll summarize again: the structural integrity of the apparatus floor, the lack of adequate decontamination zones, the inadequate dorm space for a co-ed workforce, and the mission readiness, the apparatus needing to be at the bays that face 109 to minimize response time, with some of the equipment currently being positioned to go out, as Marianne just alluded to, on Hillcrest and out Windsor, and then the same being true with the maintenance bay being there, is all about operational readiness. So if you would change the slide here, if we didn't do this, well, how might we move forward? If we had to operate a fire station headquarters out of the modulars at American Legion, we'd probably need to expand what we currently have planned as a temporary space, because that could be a much longer duration that needs to be there. And that could cost, anywhere $15–17 million. If you would next go to the next slide. If we were to put a sprung structure, what is a sprung structure? Think of it as, a pop-up garage that would house the apparatus. And then we would have, the dorm space be back inside the rest of the building. And the rest of the apparatus would end up having to go downstairs and still respond via Hillcrest. That would cost a lot of money. Could be in the $25–30 million range. It would also need land use board approvals. So again, not an ideal situation, and not the long-term solution that we need. So think of these as temporary incremental expenses. And then if we did, using the existing structure and shored up the downstairs to be able to provide adequate support for the apparatus bay, that would cost quite a bit of money as well. They would still likely need the sprung structure out on in the parking lot to house some of the additional apparatus that would no longer be able to be underneath because of that shored up lally column and I-beam setup. And again, would also require approval from land use boards. The building commissioner would need to allow a temporary structure to be used up for 1 year. And the ZBA, which can grant a special permit for that temporary structure, but it couldn't be used for more than 3 years. And I don't know that will get us to the end of the road that we need it to. So if you think about what happens if this were to drag on for several years, if this were not passed, this zoning bylaw as requested, the costs that would happen over the course of a 6-year period, 5-year period, would be somewhere in the vicinity of $6 million. Think of it as compound inflationary effect. So there would be significant additional cost to doing this and not getting to build the new facility that we have presented to you and has been unanimously supported by the 3 boards that Marianne and Joe referenced earlier. So that is sort of the cost implication of not passing what we are proposing. Marianne, I think it's back to you.
Thanks, Rob. Next slide, please. So this brings us to the proposed zoning bylaw that we're here to discuss tonight, related to municipal public safety facilities. Next slide, please. The language here is before you, and as you can see, this includes an exemption as to public safety facilities from all provisions of zoning bylaws, except for the provisions of Section 7.3, environmental impact and design review, and further defines municipal public safety facilities as facilities owned or operated by or under the control of the town of Westwood, inclusive of land, buildings, and/or structures which are used by emergency response services providers, including but not limited to the police department, fire department, emergency medical service provider, public safety department, or other municipal public safety agency. I will note that in the process of bringing this zoning article forward, we discussed the fact that other municipalities actually have zoning exemptions for all municipal facilities. But that is not what we wanted to do here. We wanted to make this zoning bylaw narrow enough, but on the advice of council, broad enough to ensure that it will allow for this project, the FS1 project. Next slide, please. So how would this zoning exemption affect future public safety projects beyond FS1? You see our public safety facilities here. We have a new police station built in 2017. We have a new Islington Fire Station built in 2016. And we are now at the point, as per the Public Safety Facilities Task Force in 2013, where we now desperately need a new main fire station, a new FS1, which we have slated here on the illustration for 2027. And the reality is that we are not going to need another public safety facility for 40, 50, 60 years into the future. And this exemption is intended only with respect to FS1. The question has been asked, could this set a precedent for other municipal or school facilities in town seeking zoning exemptions, excuse me. And of course, the answer is, in order to change zoning requirements for other municipal or school buildings, additional amendments would need to come before town meeting. We are not looking to do that at this time. We are solely focused on getting this building built. Next slide, please. The proposed zoning bylaw still requires public safety building projects to go before the planning board, still requires public safety building projects to go before the Concom if necessary. Next slide. Next slide, please. That is the next slide. Sorry, I went too fast, Elijah, my apologies. So to avoid further delays and unnecessary cost escalations, the town proposes a zoning bylaw amendment that would exempt public properties from strict compliance with zoning dimensional requirements where necessary to meet well-established public safety needs. And this approach would provide an efficient, cost-effective means of constructing critical public safety facilities, namely FS1, ensure public safety infrastructure can be built without zoning appeal, and align with the thoughtful design and rigorous review that municipal projects already undergo. I will now turn it over to Joe.
Thank you, Mary Ann. Next slide, Elijah, please. No one wants to be here. The project has undergone rigorous public review. Significant changes were made during that process. Ultimately, each board unanimously approved the FS1 project. In no way are we looking to take away from that dialogue. However, public safety buildings are simply not like other buildings. The town is committed to public review and feedback and changing design to best fit the community, but the building must be built. The town has worked extensively with the abutters, explored multiple solutions, including mediation, alternative site configurations, even purchasing adjacent properties. Despite these efforts, a resolution has not been reached, leaving the town with a no viable path forward under the current restrictions. We are all certainly very sensitive to the concerns of the abutters, but we also recognize our responsibility to the 16,000 residents of Westwood to provide firefighting staff and apparatus to them when needed, as well as paramedic and emergency medical services in a timely manner at times when every second counts. And that concludes our presentation, Ellen. We're certainly open to any questions.
Joe, if I may, there's one
Yes.
more slide that I'd like to just touch on.
Please.
One more. Is there one more right after this?
Oh, yeah. Yep.
So the fact of the matter is that this, as you know, is part of a public safety facilities plan that began in 2013. We did FS2 to help cover all of the additional need that was going to be coming from University Station, and we rebuilt the police station, both of which we were able to fortunately do within the confines of Prop 2.5, thanks to the additional revenue that came from University Station. Back then, we pressed pause on the public safety, the third leg of the public safety, which was FS1, and put that temporary solution in place. And then we allowed the schools to go forward, or worked with them to go forward, and thus we have Pine Hill. The reality is, our brave men and women, they never wait, they never hesitate, they never pause. It's time for us to respond to their call. We need to move this motion forward, this proposal forward, in order to be able to move the project forward. This is an enabling article, and we thank you.
Thank you very much. All right, before I open up to board comments, were there any staff comments?
Yes, Madam Chair, I did have a presentation, but honestly, it just includes the article language, so that is included within this one. If you guys, you as the board need to refer back, I can always go through this presentation.
Excellent, thank you. All right, then I would like to open it up to board member questions, comments, thoughts at this time. Kate, I think you got there
Oh.
first.
Thank you. I just wanted to say, in the interest of time, understanding that we'll lose Mr. Giordano in just about an hour. I just wanted to express my gratitude to the select board for bringing this opportunity to us. I'm very supportive of the project. It's an unfortunate situation, but I'm supportive of this as well.
Thank you, Kate. Phil.
Yeah, perhaps I have my thoughts, but perhaps the select board or Mr. Bailey can explain what is the impact if this pass and it passed the town meeting on the appeal? Meaning, does it moot aspects of it, meaning they no longer are viable? I think it would be useful, not just for the planning board, but also for members of the public to have an understanding as to what happens if this is approved. And that, to me, I think is just the one piece that I'd like to have a little greater explanation upon.
Thank
Madam
you.
Chair, I'm happy to jump in.
That would be wonderful. Thank you.
Thanks. Phil, you are correct. This would moot the appeal because the appeal is based on the variances that were issued. And the argument is that those variances do not meet the legal standard for the grant of a variance. This zoning article would eliminate the need for the variances and thus would moot the appeal.
Could you just, for the non-lawyers, and I use the word myself, could you just explain exactly what that means, layperson language?
Sure.
'Cause,
And
what
that's a really
exactly
good
does
question
that
because,
do?
we can be wonky. It means the appeal would go away. It would no longer have any basis. Procedurally, what would happen is that the town would file a motion of some sort. I don't know whether it's to dismiss or something else, but it would basically say there's no case here anymore because there's no need for the variances.
Okay. So in essence, by passing this, if it goes through town meeting, it is approved throughout the process. The variances which underpin the appeal no longer have the viability they had, which gave the appeal its life, essentially. And that's what meaning it would be moot. Is that
Yes.
fair to say?
Yes.
Okay. That's all I have for the.
Thank you, Phil. Marianne, I thought I saw your hand up.
I did. Thank you, Madam Chair. I just wanted to make the comment, and Phil, thank you very much for that question. And Dan, thank you for the answer. I think it's important to point out that we have had the benefit of outside counsel with respect to the language that is before you. Although I am a lawyer myself, Phil, you are, I do not practice in this area. This is a very, very specialized area of the law. And the select board has benefited from the advice of counsel in crafting language which will accomplish the goal here. And so part of what you have before you tonight, as far as language, is our reliance on counsel in terms of what language is necessary in order to accomplish the goal. And I just wanted to share that with you. Thanks again, Phil, for that question.
Thank you. Kate and then Phil.
So sorry. I beat you just by a hair, Phil, sorry. So just to be clear, under this proposal, I just want to really underscore this. Any future projects would still come to the planning board. We would go through the same process we went through before for the EIDR, where we could create conditions for a project. So the planning board still has a role in any future project where this may apply, but the intention is that there would not be any. But to be clear, we're not, this isn't the planning board saying, great, go for it. This is, I view this very differently and as a necessary action, unfortunately, because we're not able to move it forward otherwise for the town, for fire staff as well. Thanks.
Thank you, Kate. It was Phil and then Sean.
I'm now going to ask the flip side of it, and I'm going to again point to Mr. Bailey. Could you detail for the planning board and for those watching the uncertainty that would exist and what would happen with the appeal if this was not passed? So there's two aspects to this entire process, which is if it is passed, and obviously through the entire process, town meeting, et cetera, it moots an appeal. But if the appeal is not mooted, discuss the uncertainty or what happens on the other side of the coin, please.
Happy to respond to that, Madam Chair.
Yes, thank you.
Okay. A couple of things. The appeal is pending in land court, which is not unusual. It's based in Boston, and land court typically handles these types of appeals. The project cannot go forward pending appeal. Variance appeals stop any project. The time frame for getting through the land court is 18 to 22, 24 months. So even if the town were to win the variance appeal, it's probably a minimum of 18 months before the town gets through that process. There's another process beyond that, which also prohibits the project from going forward, and that would be an appeal from any land court decision to the Massachusetts Appeals Court. That would be another 2 years. So if the plaintiffs were determined, they could delay the project for up to 4 years.
So in essence, we could actually get a town approval, but because of the legal process, we could be at a standstill, and obviously then you have cost escalators and all the things that impact that. Is that fair to say, Mr. Bailey?
Absolutely. I mean, I deal with this on a daily basis. Most of my clients are developers, though I do represent municipalities. And one of the tricks in the bag is to file an appeal to tie these things up so that they can't go forward.
Madam Chair, if I may add to Attorney Bailey's answer.
Sure.
Thank you, Phil. Very good question. And, based on the timeline that Dan just laid out, this would end up costing taxpayers an additional 10 to $15 million without batting an eye, right? If you tie this thing up and we have the compound inflationary effect that I talked about at $6 million, throw another, or $250,000, $500,000 in for legal fees. And then, you probably have, instead of a temporary operations center while the construction is being done, you likely have that scenario for the full duration of the 4 years that Dan just laid out for the legal piece, and then the additional 2 years for, the construction. So you're probably looking at another $6-7 million there. So for that additional $10 to $15 million, we as a community get nothing. And we know we have many better uses for money of that magnitude.
Thank you.
Just to also jump in on that, I'm not lead counsel in the litigation. We do have a role there. But Brian Winter at Mead Tellerman is lead counsel. But I'm sure Brian would tell you that defending this appeal through trial alone is easily a $300,000-400,000 endeavor.
Thank you. That was actually going to be one of my questions. So preemptively taken care of. I see, Sean, I'm sorry. I know you've been waiting, but I see Pat Ahern has his hand up. If you're okay with me. Yes, thank you. Pat.
I apologize, Madam Chair. I can't get my camera to work. Perhaps it's photographed me too often and is now broken. Having said that, yeah, we have a cost estimate of litigation that is in the $350,000 to $500,000 range, of which we get nothing. It's another cost escalator, and I just wanted to make sure that you had that before you. Thank you for the time.
Thank you. Sean, yes.
Thank you, Madam Chair. I think I'm broadly supportive of this effort and want to see what we can do just as a matter of, I think, fiscal responsibility here. And I even remember at town meeting when we approved the money for the design of the fire station. It was, I think, pretty well laid out in the report at that time that this would exceed some of the dimensional requirements of the zoning bylaw, and that would be a natural part of this process. And I think the town at that time voted to move forward with the project and with the design, well aware of that knowledge, knowing this was the best site for this. So I've been very sensitive to, I think, a lot of concerns raised in this process, but I think this makes a lot of sense. I'm wondering if council can help me on just maybe a more technical matter that I'm getting hung up on, which is right now the language of the article as written exempts municipal public safety facilities for everything but section 7.3. However, I know there's also some sections that the planning board typically looks at across kind of parts of section 6.0 of our general regulations, and that includes 6.1 on off-street parking, 6.3 on enclosures, screening, and buffers, 6.4 on exterior lighting, and section 6.6 on noise. And then additionally, there's section 7.1 on earth material movement. I'm wondering if there were kind of well-contemplated reasons for also carving municipal public safety facilities out from those sections and not just sort of 7.3. So thanks for any information on that front.
Madam Chair, if I can jump in.
Yes, please.
Yeah, Sean, absolutely. And the way we thought about this was looking at the bylaw somewhat holistically. 7.3 environmental impact design review is a very broad review, about as broad a site plan, commonly known as site plan review, but about as broad a site plan review as you would see in any town in the Commonwealth. It incorporates not just those things that you mentioned, stormwater, open space, dimensionals, but sustainability, air quality, As I mentioned, open space, traffic, and circulation. So by retaining the ability to do an EIDR review, the planning board still has a robust, as one lawyer way back when we were doing Westwood Station described it as a site plan review on steroids. A very robust review process to look at a municipal project. The other reason that, to be really blunt about it, the other reason that we looked at this and said, let's keep EIDR review is in thinking about FS1. FS1 has gone through the EIDR review process. And I think the planning board we saw earlier had 3 hearings on it. The appeal period for appealing an EIDR has lapsed. So it keeps the EIDR on the table for municipal facilities, but allows the fire station to go forward because it has that approval.
Thank you. Sean, before I move on to Josh, did that answer your question sufficiently?
I think so. I think what I'll just note, so within section 7.3, which is the EIDR section, one of the, I think, kind of decision criteria or standards on which the planning board's supposed to make a decision on site review is 7.3.9.8, which talks about ensuring compliance with the provisions of this bylaw, including parking, landscaping, exterior lighting, and noise. However, those provisions are covered in section 6.0 instead. So I'm wondering if part of that EIDR process gets neutered for municipal public safety facilities if we are exempting municipal public safety facilities from section 6.0. I hope I'm making sense there. I'm just thinking through, and we had a very robust discussion on this project over things like exterior lighting, noise, screening of the parking area, screening of kind of the dumpster of the generator. And I thought that was an important discussion to have, and was a big part in making the project, I think, as strong as it could be. So, and additionally, off-street parking, for example, that's covered within section 6, but that has some of our ordinary requirements around having certain accessible spaces, etc. And I would just want to make sure we're not creating issues by carving out municipal public safety facilities from those section 6.0 regulations.
Again, Madam Chair, happy to respond to it.
Thank you.
I don't think you are, Sean. And the reason is that you do have the specific authority for things like parking, traffic circulation, any public safety facility, any facility that goes through the EIDR process is going to be, the planning board takes this stuff very seriously, and you have hearings and you have lots of public input. And let's say that even if the parking requirements, which are typically handled on a per project basis, you're going to make sure that the planning board is going to make sure there's enough parking. You're going to have the authority to deal with landscaping and screening and all of those important issues that come up on a building, whether it's municipal or commercial of this size. So when we were thinking about it, we felt pretty strongly that, look, as a lawyer, if I drafted this the way I wanted, I would have done a complete exemption from anything. But my client, the town, told me that that was not what was desired. So we thought about, how to thread the needle to make sure that there is a robust public discussion and review, but also making sure that the hard issues, which tend to be dimensional on these facilities. I think everybody has heard about how if this facility, it already would have required, the existing facility would have required 4 zoning variances. that we address those dimensional issues.
Okay, that's very helpful. And I think my main thought process in all of this is we've got a pretty long zoning bylaw, as you know. And I wanted to make sure we just kind of had covered some of the ifs, ands, and buts there, but sounds like it's been pretty well contemplated, and I appreciate your effort on this and the town's effort on this. Thanks.
Thank you. Josh?
Actually, I was just curious about the actual appeal. So again, to make it clear for everybody, this appeal was actually against the variances that were approved by the ZBA, correct? Yes. So sort of dumb question, if somebody decided they wanted to appeal EIDR in any permutation, whether waivers that we presented or conditions that we put on it, would they be able to do that?
Not for this facility.
Not for this facility, I'm saying.
But in the future, absolutely. Yeah.
So
Yeah, your regs say that, and I don't have the exact regs. It's either a 20 or 30-day appeal period from issuance, from filing of the EIDR with the
it's 20.
with the town clerk.
So what we're saying is that because that time has already lapsed, and because the applicant, the aggrieved individual, decided to wait for the ZBA to either approve or deny it, we're in the clear now because this would forego the need to go to the ZBA. Hence, the appeal is, as Phil and yourself put it, mooted. But that doesn't protect us in the future either, right? Because you can still file an appeal for an EIDR. So my challenge here, there's a couple, is we followed the right process, right? Everybody here, the ZBA did the right thing, we did the right thing, and now we're saying that we hope that this will pass town meeting and it will be approved by the Attorney General, which is also up to 180 days. Am I getting that right?
4 months, 120.
120? Okay. And all this is not impacting the project, right? So I'm hearing a lot of numbers getting tossed around. Oh, it's 15 million here. This other part of the project's going to cost 8 million, which I have a lot of trepidation around without seeing any formal quotes from anybody as well. I actually buy the legal costs the most, but all the other permutations of, hey, it's going to get closed down because of this or that, I have a lot of problems with that. And I actually strongly feel that we've done the right thing, that we should, I don't know, have we made motions to dismiss this already as a town? Why?
I can answer that.
Okay.
We, in our initial trial conference, we indicated we wanted to do a motion to dismiss. And the judge said she was not going to entertain it at this time. It's her preference that we've got to wait till she'll entertain that motion, or else take an interlocutory appeal, which would add more time to the process. So no, we have not done a motion to dismiss. We are prepared to file one if necessary, but I don't know how successful that would be.
Okay. And I'd also like to understand how during this, I guess the mediation failure, what was the, why did the mediation fail? How did we come this far apart where this was an existing structure, the individual knew it was here. I've seen only betterments in from public comment, like there was a lot of commentary around light pollution and stormwater, which we both mitigated to a large extent. So I'm confused as how this person is aggrieved by this.
So I don't think we said the mediation failed. I think we said
Okay.
it stalled.
Stalled. Okay.
Okay, because these are hard things to get done through mediation. It's stalled, but we're still working at it, and we're still hopeful that we can come to some resolution.
Okay. And how is this person saying that they're aggrieved? Like, what is the appeal about? Like, why is this a problem?
Well, they're appealing the variances, and they have not pled with specificity for us what their damages are. And that's something, should litigation move forward, is something we would be seeking. It
Yeah.
would also be the basis for a motion to dismiss, that it's not pled with specificity.
Yeah,
So-
yeah, that's my confusion here, that we're doing all this based off of something that doesn't feel like it's actually been fully baked. But I see everybody wants to talk and shut me up apparently. So let's go. I will take
I don't
my-
want to shut,
I
I
know.
can assure you, I don't want to shut you up, Josh.
I'm just
Your
seeing all the
question-
other hands go up.
Your questions are fine, from my perspective.
Thank you. Phil, if you're amenable, I'll go to Elijah first and then to you. Phil's nodding.
Yes.
Elijah.
Madam Chair, I just wanted to, I guess, give a cautionary comment to the board, just understanding that this public hearing is to take on the zoning articles, and, you know, deviating too far off from that may not exactly follow the public hearing as advertised.
Thank you. Phil, and then back to Josh.
I'll be brief because I've already spoken too many times and I'm the one causing some of the time constraints. I think the issue is the inherent breadth and tension with the narrowness. And that what I mean is this is a broad bylaw. And if it was not narrowly tailored to public safety buildings by the municipality, I would have much more problem with it. I would, for example, if it went into schools or all these other things. For me, the narrowness and the by a kind of laser beam focus for it being public safety as compared to a broad stroke of municipal buildings is much of the tipping point from the breadth of what is being done. So there's a tension that I think you're hearing from all of us. I obviously have been a supporter of the FS1 project, and not to play lawyer, just know how litigation can take forever, and it can have all sorts of uncertainties despite the predictions. And to me, it is actually a logical conclusion, and the tension works to the town's benefit, meaning that this is a zoning bylaw that makes sense. So just I'm going to stop talking.
Thanks, Phil. I think Josh was either still up or back up, and then Kate.
Kate can go.
Okay, Kate.
Thank you. I really appreciate all the discussion from the board. I think it's been really valuable. I do just want to say, around this feeling of a sense of urgency. I think that more, for me, that more speaks to the cycle of the town. It isn't so much urgency. I mean, this is certainly an overdue project, in my opinion. You know, we're decades late on this. The urgency around, you know, this extra meeting tonight, it's just the way that all of these different timelines line up. And as Phil said, you know, the narrowness of what's before us, I feel is appropriate. And we just don't have, this seems to be the right time to take this particular action around this project. But I very much appreciate the discussion. And I do just want to go back to what Sean was saying about the EIDR. That was my feeling from the beginning, Sean. During the EIDR, the planning board can address everything in section 6. That's why it's so critical that it's still in there. But I appreciate you getting really granular about that. And I am, I believe, done commenting on this. Thank you.
Thank you, Kate. Josh.
So again, just to go through the litany of other questions I have. So did we asked the neighboring property owner if they were interested in selling? Did we show any interest in an order of taking or eminent domain, if this is such a problem?
I can answer that. We did not entertain an order of taking.
Okay.
We tried to negotiate with the neighbors, or the neighbor, and they told us that they were not interested.
Okay. I heard that there are a number of other towns that have similar or more broad language. I had a lot of trouble, and I even asked, and I saw some sort of related but not identical language. I think that there are examples out there, but saying that this is a broadly adopted sort of bylaw seems to be a stretch. Can anybody give any clarification on the other examples? Examples of towns that have this bylaw or a similar bylaw? Thank you, Rob.
You're muted, Rob.
Muted, Rob.
My apologies. I believe Pat talked earlier about some of the towns that have, or maybe it was Dan that talked about some of the towns that have a, you know, broader exemption for all of their municipal buildings. For example, like the town of Hanson, where not only are municipal buildings exempt, but anything owned by the Hanson Housing Authority shall also be exempted. So something like that goes far beyond the scope of what it is we're trying to do here. I think we all agree that this is needed. I think you know that we have proceeded to bids, which will be opening next week. Those bids will have a time period for which they are good. And, you know, at this point, we didn't take this action lightly, but the urgency of moving this forward and doing so in order to exercise our greatest fiduciary responsibility to the town, as well as providing for the public safety and the public good, made this a necessary, as I said before, we still hope to get to a settlement, but hope is not a strategy. And so we have to put this forward in order to make the variances and therefore the appeal moot.
Okay, so I'm hearing that we have like one other example. Do we
No,
have
there-
other?
That was one I cited where it
Okay.
goes far broader.
Okay.
So, Josh, I have a document that outlines all kinds of municipal things. I can't get to it right now, but I'll be happy to send it to you tomorrow.
Okay, Molly seems to have her hand up, so maybe she has a better answer.
Yeah, thank you, Molly.
Thank you, Madam Chair. The examples I have at my fingertips right now are Chelsea, all municipal buildings are exempt. Danvers, all municipal buildings are exempt. Douglas, Dudley, Hanson, and Paxton. And like Pat said, there's a number that have slightly different. Those are just examples that exempt all municipal buildings from zoning bylaws.
From all zoning bylaws. So that
Correct.
is much broader than what we're presenting as very narrow with public safety and still inclusive of our EIDR.
Correct.
Yes.
Perfect.
And part of the reason I cited the Hanson one was because it actually went further, right? It expanded that to include the housing authority.
And I guess my last sort of, I don't know, feeling around this is we made a comment earlier around we've done a lot of improvements around town within Prop 2.5 without needing to do, you know, a ton of overrides and you know, other mechanisms to raise funds. But I'm also hearing today that we're so worried about FS1 that it is an imminent safety concern. Like, how did we let it get this far for this long? I'm struggling, and I know I'm going off topic a little bit, but what we're being asked to do is a little bit like undermine a legal proceeding legally, but that is our strategy by doing this. And it just feels conflated with what we're saying. We're being very verbose and very proud of how we've handled these things, but now we're also saying, well, we need to do this urgently right now because it's an imminent safety concern. And being in the safety field, I take that very seriously. This isn't something that comes up overnight. So how did we allow this to occur over such a period of time where now it is vital that this is passed or supported tonight, which I guess is not even. We can take a vote now and it still goes to town meeting, correct?
Yes.
So
Rob,
I'm happy to answer that, Madam Chair. Josh, this is not something that what came upon us out of the blue. As I said, we had a public safety facility study that was done in 2013. As part of that, the then select board prioritized the order of improvements, and this one had a temporary solution that was put in place. You have seen all of the visual evidence. You have heard all of the testimony as to why this is necessary now. And in fairness to the men and women of the fire department, they have known and waited patiently for their turn, if you will. And we are at that point. And if this doesn't go forward, whether it's, I'm just very, very concerned that somebody drops a dime to OSHA and somebody comes and looks at that building and says, this is not inhabitable. And now we have a temporary solution that we have to pay for an extended period of time. And we don't have anything that is a long-term solution. And so, yes, we have tried to work with the abutters. I agree with you that I don't necessarily understand why there is the appeal. However, that is for the courts to sort out. How this action, this legal action, if approved by town meeting, would in fact bring that to closure. And that
Awesome.
is in the best financial interest of the community, as well as the best safety interest of the community.
thank you.
you. Kate,
Yeah, thank you. I just also wanted to go back to the why now piece. And you know, we've been talking about Fire Station 1 right alongside the Pine Hill School. Why Fire Station 1 needed to wait? Because we were focused on the Pine Hill School. And why Pine Hill School and Fire Station 1 needed to wait? Because they were after the Islington Fire Station. So not us necessarily, but there have been discussions from residents that I have been part of that's like, look, there's a plan for the order in which we are, or there's a, not a plan, that's, I'm not a privy to some big plan, but the conversations, and I appreciate that you're not hearing the same things, Josh. I'm just letting you know, Fire Station 1 has been on my radar for more than a decade. And for the same reasons we know about today, they just were not able to be addressed.
You're misunderstanding me, Kate.
Oh, okay. Thank you.
This is not about the prioritization of when we do a project. It's about the fact that we're saying this is an imminent safety concern. We don't get to prioritize when something's dangerous for our men and women that protect us at night. So if it was always this issue, then it should have been rectified. If it's not that issue and it's just a prioritization of projects, I can support that. But when we start saying people are in danger, that's a full stop. That is now bordering on malfeasance, which is a legal issue. So let's think about this really closely when we're making determinations around why we're doing this. It is not because somebody will get hurt. And if it is, shame on us. We need to remedy that immediately. I am complete support of FS1, complete. Let me make that very clear. This is not necessarily about FS1. This is about creating a new bylaw that exempts municipal buildings, public safety buildings. That is my only concern around this. I, again, made it very clear that I don't see how anybody could be aggrieved from this. I am in full support of FS1. I am in full support of not wasting money, to be quite frank. But this is something that we're doing that we don't know the exact consequences afterwards. And it does feel like it's a deviation from what we would expect the process to look like in terms of an appeal. and we go through the appeal. We stand up behind the laurels and the merits of all of our decisions. So thank you, Kate.
Thank you to both of you. Phil. You're muted, Phil.
Yeah, no, I'll be very brief. I think we've had an expansive discussion about how we got to where we are. I view it as kind of a practical, and just in any case that's in any court, each side has certain merits and each side does not. And if we, on behalf of the town, can strengthen our merits on a legal basis, and this is not something that's inappropriate as a process, I think it is, if the project itself is worthy of being approved at town meeting, getting to that process without the delays which the legal process creates. It does. I mean, adding 4 years with hundreds of thousands in legal costs, which cost escalators of construction and everything else, doesn't get our men and women any safer. They obviously have a delay, and you get to the same result, except you just spent a ton of money and you had a situation which is at risk. I completely agree. The past, but the past is the past. How we got here is how we got here. Sitting here today is a choice and a decision that I think this board has to make. And it is, in my view, not necessarily in the best interest of us, particularly in light of the appeal, not to move forward at this time. So I've said way too much. Thank you, everyone.
Thank you, Phil. Given that we have some time constraints with you, and I think the goal is to take a vote on, at least have you here for this article, I'd like to open up the floor for public comment at this time.
Madam Chair, I can try to log in through my phone at 8:30 and then try to rejoin if that works, to give, because I do want the public to have the opportunity to have some comments. So that, just if we could take a short pause and then rejoin by my phone. I'm just trying to give everyone the opportunity. Thank you.
Thank you. Yeah, I was hesitant to cut discussion on any front off, as this is important. So if the board members are okay, I'll move on to public comment, and then if we have time, we can loop back through board members. I don't see any objections. At this time, I'd like to open up the floor to public comment. Please either raise your hand, we can enable you to speak, or enter your question or comment in the Q&A. Reminder, we need your full name and address, and we were offering a 3-minute opportunity per speaker. Okay. In the interest of time, I'm happy to read the comments. We have, if I mispronounce this, I apologize. Juan Lee Pierce, 17 Salisbury Drive. I urge you to press the Westwood Zoning Board of Appeals and Town Administrator Christopher Coleman to promptly settle the land court case with the plaintiffs. Those elected or hired to serve Westwood must prioritize our community's interests, not squander taxpayer funds on costly litigation. Article SB 11 is not the solution to the new Fire Station 1 project's challenges. It only invites endless risks for Westwood. Thank you. I see. Oh, good. Okay, thank you. I saw Bob Folsom has his hand up. If we could enable him to speak.
Yes, it's been enabled if you unmute.
Thank you.
I assume you can hear me now?
Yes.
Bob Folsom, or Robert Folsom, 35 Smith Drive, also 649 High Street, Folsom Funeral Home, right next to the Fire Station 1 project. I've kept a very low profile in this whole process. I have spoken to several people involved, but this, when I saw this bylaw, I have to say that this really annoyed me and bothered me. What are the reason for bylaws? They're to protect the town, but they're also to protect the abutters. And being probably the primary affected abutter to this whole project, taking away any rights that I have next to the building, the fire station, it does not please me at all. I'm not opposed to the fire station. I am one of those abutters who was here before the aging fire station was aging. There was a piece of property between my funeral home and the original fire station put on the addition in the early 70s. I remember taking that house down and the fire station getting closer to us. We supported that. We support the changes needed for the fire station. But my objections, my concerns were that you're putting a very high building, a very long building, very close to my building. Kind of resigned to the fact that that probably will happen, and that's going to make a couple of years of very difficult times for my business. But taking away all the zoning regulations, so you could come right to my property line, not have to tell anybody about it. That annoys me and that bothers me. I view this as an ends justifies the means type of bylaw. I understand you're all invested in it. You're looking after the financial aspects of the town, and I'm not part of the lawsuit. Let me make that clear. So I'm speaking only as your closest abutter on the side of the fire station. But they have the right to oppose it and go against the Zoning Board of Appeals legally. That's part of our process. And I think if they, and maybe some of my concerns had been listened to earlier, we might not be in this position. I think you've got yourself in a position where you've got one option and one option only, and now you've got to sink or swim with that option. And, you know, I'm sorry for you on that position. Anytime I have done work and had an architect, I've always had multiple options presented to me. And then we were able to look at all those options and see what fit all the plans. And it looks like the town had one option from the architects, and that's what you're going with. So that's what I can say.
Thank you. All right, it looks like we have a couple more in the Q&A. These are both from, I apologize for the first name, Xiao Kyung Ada Zong, 73 Partridge Drive. I urge you to withdraw Article SB 11, which exempts municipal public safety facilities from most zoning bylaws. While I support public safety, this proposal removes critical oversight, risking developments that could disrupt neighborhoods with noise, traffic, or designs that don't fit Westwood's character. Section 7.3 alone can't address all concerns like parking or setbacks. This broad exemption could also be misused in the future, eroding trust in our zoning process. And her second comment, please stop labeling anyone who opposes Article SB 11 as anti-new fire station 1 project. Thank you. I see, Elijah, yes, thank you.
Yes, just wanted to remind anyone who would like to speak of the limiting your comments to 3 minutes so we can allow others who haven't already made comments to make comments. And then I guess I just wanted to touch on a few pieces that were mentioned as it relates to letting abutters know in this proposal. The EIDR public hearing process would still give abutters notifications, so abutters would be aware of any proposed development. It is, as others have mentioned before, a very comprehensive process. I would dare say during this past hearing process, the planning board fielded, I would say, a very comprehensive set of public comments, and as compared to other boards and committees. And so I would just reiterate that the EIDR process would still give residents a say in the development of a project.
Thank you, Elijah. I'm not seeing any other hands up in the attendees, but we do have another comment from Wanley Pierce, 17 Salisbury Drive. Article SB 11's removal of zoning restrictions for public safety facilities could lead to overdevelopment. Unchecked projects might overwhelm streets or crowd homes, disrupting our town's balance. Please withdraw this article to ensure developments respect Westwood's scale and livability. Thank you. One more from Only Pierce. I'm deeply concerned about Article SB 11, which would strip away zoning oversight for public safety facilities. This limits our ability to influence critical decisions about size, location, or impact, potentially harming neighborhood character. Withdrawing this article is essential to maintain community input and trust. Thank you. I think that is everything that's been entered into the Q&A. If anyone sees anything I've missed, please let me know. I don't see any other hands raised. If we have time, I have one quick question. I was holding it. Phil, do we have time for one quick one for me?
Yes, like I said, I'm gonna log off and then re-log in by my phone, so we can go past my hard stop. If we can take a pause until I can re-log in, that would be great.
I think we can do that. My one question is around the language in the definitions for municipal public safety facilities from the last part, including but not limited to the police department, fire department, emergency medical service provider, public safety department, or other municipal public safety agency. The first part is highly specific. The second part is a little more generic. I'm just wondering what other types of facilities this could possibly apply to under that umbrella, or if that's just kind of boilerplate language.
I'm happy to respond to that.
Thank you.
It would not apply to anything other than a police station or a fire station.
Okay. Thank you. I appreciate the clarification. Okay. I see one more comment in the Q&A, also from Ada Zhang, 73 Partridge. Amending the zoning bylaw is not the solution to the new Fire Station 1 project's challenges. It only invites endless risks for Westwood. I urge you to press the Westwood Zoning Board of Appeals and Town Administrator Christopher Coleman to promptly settle the land court case with the plaintiffs. This is pretty reiterative of a previous comment. Those elected or hired to serve Westwood must prioritize our community's interests, not squander taxpayer funds on costly litigation. All right, noted. I think we heard that twice. Thank you. Okay. Are there any other questions, comments, discussion on this article from board members or staff? I'm not seeing any additional hands for public comment, nor am I seeing anything else in the Q&A. Elijah.
I would just like to note that we did receive 1, 2, 3, 4, 5 email public comments that will be submitted into the public record.
Thank you. Yes, I believe we received them, and thank you. Any other comments, questions from board members on this? I believe we're going to take each of the proposed select board sponsored zoning articles individually. Yes.
That's correct.
Okay. So if people are in a position to move to a vote at this point, if there's no further discussion, looks like we could do this before Phil had to get in the car, and then maybe we could take a pause before we move on to the next article.
I move that the planning board oh, go ahead.
Oh, no, I just wanted to, one last call for any questions or comments from board members or staff. One more thing has popped up in public public participation. I believe we've actually already had this comment. Someone correct me if I'm wrong, but
It looks like a repeat.
A repeat. Yes, thank you. All right, with that, then if there are no further questions, comments, or discussion from board members or staff, I would entertain a motion.
I move that the planning board recommend favorable consideration of the following proposed select board sponsored zoning bylaw zoning map amendment warrant article by the Finance Warrant Commission and by voters at the May 2025 annual town meeting. SB 11 zoning bylaw amendments relative to municipal public safety facilities.
I second the motion.
I have a motion and a second. Any further discussion?
I just want to say that there's another public comment that came up that seems repetitive, so I don't think there's a need to read it back into the record.
Okay, thank you. All right, I have a motion and a second. Any further discussion? Seeing none, I will take roll call. Kate,
Aye.
Sean,
Aye.
Phil,
Aye.
Josh.
Aye.
I vote aye as well. The motion carries. All right. It's 8:25. Does that make sense for us to take a brief pause, let Phil get in his car? Maybe we take a bio break and then reconvene and move on to the second article. Does that make sense for you, Phil?
That would work for me. I'll just jump in, just give me 5 minutes if possible when you see me back in the room. If you could let me rejoin as a panelist, that'd be great. I appreciate it.
That sounds good to me because I would love to have you for the next two as well. It would be good to have all board members.
Great.
Thanks everyone for getting through that first one
Thank
as
you.
efficiently as we and thoroughly as we did. All right, so is that amenable to the select board as well? If we take a short recess?
Yes, sounds good.
Great. All right, then I would entertain a motion to briefly adjourn until for 5 to 7 minutes and to reconvene within 5 to 7 minutes and bring Phil back in.
So moved.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take a roll call. Kate,
Aye.
Josh,
Aye.
Phil,
Aye.
Sean.
Aye.
I vote aye as well. Not sure if the select board needs to go through a similar exercise.
I'm gonna guess Pat will say yes. Mary Ann, would you be so kind?
So we're moving for a recess in our meeting. So moved.
Is there a second?
Second.
Roll call, Mary Ann,
Aye.
Rob,
Aye.
I vote aye as well. Thank you, Ellen.
Thank you. We'll see you momentarily. Phil?
Aye.
And I vote aye as well. We're reconvened. Select board?
Would anyone like to make a motion to reconvene?
So moved.
Second.
Second. Roll call, Mary Ann,
Aye.
Rob,
Aye.
I vote aye as well.
Fabulous. Thanks everyone for your patience and glad we were able to keep Phil on. We will move on to the second select board article, Article SB 12, zoning bylaw amendments relative to flood area overlay district, FAOD. Happy to hand the floor over to whomever is making the presentation on this one.
Yes. So I do have a few slides are related to this. I can share with the board. We are also joined by Karen Skinner-Cutroni, the conservation agent, and Christopher Coleman, town administrator. So I will do my brief presentation and Madam Chair, I would return it back to you or the attendees.
Thank you.
Proposed Article SB 12, Flood Area Overlay District, FAOD. The main changes to this article include an update for the district section of the zoning bylaw to meet FEMA standards for flood insurance eligibility. The proposed amendments track with the model floodplain bylaw. Specific updates to the section do include the purpose, definitions, reference to FEMA maps, firm data, and supporting studies. The designating of the building commissioner as floodplain administrator. Additional permitting requirements that might increase flooding or adversely impact flood risks to nearby properties, notification requirements when new data shows changes to the base flood elevations, as well as reporting requirements. I just want to stress that this was brought up for the main reason that if the town does not take up this zoning amendment, it would invalidate flood insurance for property owners in the town, which would be catastrophic. And so it is imperative that the board consider this proposal. I do have the actual bylaw laid out in following the slides. However, I could turn it back to Madam Chair or any of the attendees on the panel to further make a comment.
Thank you. Karen, Chris, anyone from the select board team, was there anything you would like to present or add to what we're looking at?
Madam Chair, I just want to thank Elijah. I thought that was a very thorough review of the article and also the potential impact, if it doesn't pass. So thank you.
Thank you.
No,
All right.
I think the select board's in favor of this, Alan. It's common sense, something that has to get done.
Thank you. Any other input or materials from folks that are here representing this article?
So I'd just like to say the Conservation Commission has recommended this also, so. And if it isn't approved, Westwood residents will lose their flood insurance, so it's serious.
Absolutely. Thank you. From my perspective, it's pretty cut and dry. Thank you. All right. I will open it up to board member comments or questions. Josh?
Yeah, I was actually just wondering when this went into effect, the change of the map. Anybody?
So it's we do have this does incorporate new maps or changing of the numbers. So just recently, probably within the last month or so.
So what we're saying is the maps have changed over the past month and we're expected to comply with that?
If I could just add to that, so the section 9.2.3 in the amended language shows the date of effective validation of the new maps is July 8th, 2025. So the new maps have been discussed since, I believe, last fall, and we are required to adopt amendments to our bylaw to bring Westwood's bylaw into conformance with the FEMA requirements for the model state bylaw. The new maps will be effective as of July 8th.
Okay. And when was this passed for the change though, like the roll-in period for effectiveness?
January 8th, I believe.
Of this year.
Of this year, yes.
Okay, that's it.
Thank you. Any other questions or comments from board members? Not seeing any hands up. All right, then at this time, I'll open up the floor to public comment on this article. Please raise your hand and we will enable you to speak or enter your question or comment in the Q&A. Full name and address, please. And 3 minutes per speaker. I see one here from Wanley Pierce, 17 Salisbury Drive. As we consider the addition of section 9.2.13 requirement to submit new technical data, what do you see as the potential pros and cons of including this new section in our regulations?
I guess I could take a go. I would say that the including new technical data is imperative as we are facing a changing climate. So there are, the actual amount of, I guess, the water table, as well as, annual precipitation, as well as the intensity of rain events, all factor into new data that would be needed to be included in this amendment.
Thank you. Second question from Wanley Pierce, 17 Salisbury Drive. As we consider the addition of section 9.2.15, variances to local zoning bylaws related to community compliance with the National Flood Insurance Program, NFIP, what do you see as the potential pros and cons of including this new section in our regulations? Well, I can try this. If I understand correctly, the pro to adding it is we get to keep our flood insurance, and the con, if we don't add it, is we lose our flood insurance. Did I get that correct?
Yes, that's correct.
Thank you. Thank you. All right. Ada Zhang, 73 Partridge Drive. I'd like to hear your thoughts on the proposed addition of, sorry, that just moved. Did that disappear? Did someone mark that? I'm sorry.
Might be in the answered column.
Yes, thank you. I'd like to hear your thoughts on the proposed addition of section 9.2.5, permits required for all proposed development in the FAOD. What do you see as the key advantages and potential drawbacks of requiring permits for all types of development activity in the flood area overlay district?
Yeah, so making sure that these types of uses and proposals are permitted ensures that we allow for the public process and applying the necessary standards as prescribed from FEMA to make sure that we do maintain good custody of the land in maintaining for potential flood risks.
Thank you. Fran Fusco, 20 Pine Lane. Nora, why is this just being addressed now and not years ago? If I understood correctly, these are new new changes to the law, right? So this, I believe we were in compliance, and we wouldn't be if we didn't make these changes because, for lack of a better way to put it, the goalposts have moved.
That's correct. So the
Okay.
Flood maps have changed over the years. Every few years they change. I think the most significant change I recall was in 2012, and our bylaw at that time was compliant. The maps changed, the flood areas changed, and we made some tweaks to our bylaw to address what used to be called 1% and 2%. They just changed their terminology. So we updated our bylaw at that time, and now there are new changes effective July 8th, or came into play July 8th, effective, came into play in January 8th, effective July 8th. And these are new language changes that we are required to add to meet those new requirements. So it's not something that we could have done years ago.
Thank you. All right, I have one more from Ada Zhang. I respectfully ask how many public inputs you have collected regarding the SB 12 zoning amendment. If you vote today, how will you justify that your decision fully represents the community's voice? Please ensure your process clearly demonstrates thorough consideration of resident feedback. I thought I saw a hand go up on that one. Yes, Sean, thank you.
Thank you, Madam Chair. Not to jump in and speak on behalf of others here, but I do, I sometimes we do have articles like this that I believe are they're both technical, but they're also quite straightforward in terms of our staff is really putting the time to make sure that we are compliant with what we need to be compliant with at a state and federal level on an ongoing basis. And so certain things like this, I think, even if we're proceeding forward today, we've certainly given some thought to it. We appreciate the public comment here tonight, but I'll make one more note beyond that. We're making just a recommendation to the select board here tonight. If the select board then chooses to advance this to town meeting is the ultimate forum for public comment. And fortunately, we live in a town with town meeting form of government where any resident who's a registered voter in town can show up and I think make their voice heard on these articles at town meeting, whether they have concerns or whether they're supportive. So I certainly want to encourage that. And even if we've looked at this and viewed this as sort of, this is good, this is all in the clear from sort of a technical standpoint. We think it makes a lot of sense for us to be in compliance with FEMA standards. Certainly encourage you to give these things a closer look if you're interested, and raise some of your thoughts at town meeting.
Thank you. Good answer. Kate.
Thank you. I did just want to throw in my 2 cents here. You know, we are an elected planning board. We were elected to look at issues that are brought before us and make a determination on what we believe should then happen with the issue that's brought before us. The planning board, I just want to clarify, we certainly talk with our neighbors and welcome public input, but we are not always asked to take the issue before us and then go out to the community and see what they think. This is actually the place where you bring something to us, we tell you what we think, and then other things can happen from there. We are not required to go out and find out what the community thinks about every issue that is brought before us. We are elected to go through a different process. That's my view. I do appreciate the question, but that's not the process as I have been doing it for 4 years. But thank you for the question, the clarifying question.
Thank you, Kate. Yes, I think that this is the forum in which we begin to collect public input, as my colleagues have said. And I like Sean's answer. Town meeting is the venue when these articles, if they continue to move forward, everybody who attends, we welcome that feedback, and there's usually a lively debate. So we hope we see people at town meeting. All right. I'm looking, I see another question, but it seems kind of repetitive unless someone wants to disagree with me on that, but I believe we've addressed this. Unless if someone wants to contradict me on that, I'm open to that, but I do believe we have answered that question, worded slightly differently.
Yes.
Thank you. All right, if there is no additional new public comment, I'll turn it back to the board and staff for any final comments before I would entertain a motion. All right, I'm not seeing any further discussion from my colleagues. Then I would entertain a motion.
I move that the planning board recommend favorable consideration of the following proposed select board sponsored zoning bylaws, zoning map amendment warrant articles by the Finance and Warrant Commission and by voters at the May 2025 annual town meeting. SB 12 zoning bylaw amendments relative to flood area overlay district FAOD.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Kate?
Aye.
Josh?
Aye.
Phil? Please, Phil, you're muted.
Aye.
Thank you. Sean?
Aye.
I vote aye as well. Motion carries. All right, and our final article to discuss this evening is SB 13. Sorry, I'm scrolling down. Zoning bylaw amendments relative to assisted living residences and nursing or convalescent homes. And who will be presenting on this article?
Yes. So, thank you, Madam Chair. So this article, as previously mentioned, laid out here, SB 13, assisted living residences and nursing or convalescent homes. This relates to a previous provision that the planning board was considering in their last round. However, as opposed to the incentivizing of the hotel use, this specifically looks at the restriction of the residential uses as the town contemplated their split tax rate and looking at this specific site. So this looks to reduce nursing or convalescent homes on 10 acres or more with a maximum of 2 beds per acre. An example would be a structure or structures on a 15-acre site could have a maximum of 30 beds. Additionally, assisted living residences on 10 acres or more with a maximum of 5 units per acre. So an example, a structure or structures on a 15-acre site could have a max of 75 units.
Thank you. Rob, I see your hand up.
Thank you, Madam Chair. Yeah, I mean, this is before you, as you all had considered this through your hearings and discussions with respect to the addition of the hotel use. You had some significant discussion to then sort of limit the residential uses, but that couldn't move forward due to the way that the hearings were advertised. And so when you had to withdraw that article, we thought, well, we need to come before you for these other 2 articles anyway. So let's bring this back before you to try and get what you intended done. We considered sort of 3 different options. And this is the one that we landed on because we knew that you wanted to continue to take up some of the other considerations that you had discussed. So this is as much to make it so that you could have this go forward with the intent of what you were trying to do.
Thank you. And excuse me, I personally am very supportive of this. I think I said many times at our meetings that for me, this was perhaps the single most important thing to get done immediately. So I am very supportive and thankful to the select board for using one of their open articles to move this forward. I know I usually don't jump ahead of people, but it seemed like a good segue. So with that, I'll open up the floor to my colleagues for board member questions and comments. I'm not seeing any hands raised. All right. Yes, Sean.
I'll just say that I'm supportive as well and appreciate the select board using one of their articles to bring this forward. And looking forward to the continued conversation on the ARO district and some of the parcels that we were having discussions about with respect to that going forward and having the more comprehensive conversation. So
Thank you. Yes, same. Kate.
Yeah, thank you. I just want to say that, very grateful to the select board for taking advantage of what they had and bringing this to us. I just think it shows the resourcefulness of and the creativity on our select board. Very grateful to the 3 of you for your service this year. You're very grateful.
Thank you, Kate. All right. Any other board member questions or comments? I do see a few things popping up in the Q&A. All right, then I'll open it to public comment. Please use the Q&A or raise your hand to be enabled to speak, full name and address, and a 3-minute limit. Thank you. All right, first one is Wanley Pierce, 17 Salisbury Drive. I urge you to maintain your previous decision to withdraw Article SB 13. Just to clarify, this article is not the same as the article we withdrew. This article does not include adding a hotel use. As Mr. Gotti explained, we will be exploring all uses for the ARO zone over the course of the coming year, I believe. We have plans to discuss that, to do a comprehensive review of what types of uses we'd like to allow. This article is very limited. It simply limits the density for potential residential development, which is an already allowed use. So I would not support withdrawing it. I think this is important, and I appreciate your concern, but I just want to clarify it is not the same as the article we withdrew. It's quite different. The next comment is similar from Ada Zhang, 73 Partridge Drive. I trust that your original vote against the potential amendments to zoning bylaw relative to administrative office research zoning district reflected the broad sentiment of our community. If you're now considering a different stance, I respectfully urge you to maintain your initial decision unless there's a compelling, transparent reason for the change. Please share any new factors justifying a reversal, as the concerns that led to the first rejection still resonate with many of us. As I stated, I do not consider this a reversal at all. And if my colleagues disagree, feel free to jump in. It is not the same article. We are not addressing any commercial uses. It's simply limiting the residential uses that are already allowed there. And I believe this next comment is repetitive of the one we just read. All right. Any other public comment on this article? I'm not seeing any hands raised. Any other further discussion or comments from board members, staff from either board, either staff, all staff? All right, seeing none at this time, I would entertain a motion.
I'd seen Mr. Gotti's hand briefly, but.
That's okay.
Oh,
Go ahead.
Okay.
You're good.
I'll take this one. I move that the planning board recommend favorable consideration of the following proposed select board sponsored zoning bylaw / zoning map amendment warrant articles by the Finance and Warrant Commission and by voters at the May 2025 annual town meeting. SB 13, zoning bylaw and or zoning map amendments relative to the Administrative Research Office, ARO District, and or assisted living residences and nursing or convalescent homes.
Second.
I have a motion and a second. Any further discussion? Seeing none, I will take roll call. Kate?
Aye.
Sean?
Aye.
Josh?
Aye.
Phil?
Aye.
I vote aye as well. Motion carries. All right. I believe that was all the business portion we had. I believe we would need to, actually, my recommendation would be that we not close our public hearing at this time and continue it to the Finance Commission meeting on the chance that there would be recommendations on their part that we might want to, or select board might want to revisit portions of any article. If there's no changes, obviously that's fine, but that's kind of standard planning board procedure with zoning articles. We tend to keep our hearing open until the FinCom, till we've presented to the FinCom. Just in case any changes need to be made, it leaves the option open for that. Hopefully it's not necessary, but I would recommend that you take that option. Unless there's any objections from select board, that would be my recommendation, is that we continue the public hearing to the Finance Commission's, was it the April 28th meeting?
Yes.
That's correct.
All right.
I move that the planning board continue the public hearing for consideration of proposed select board sponsored zoning bylaw / zoning map amendment warrant articles to a meeting of the Finance and Warrant Commission via Zoom on Monday, April 28th, 2025 at 7 p.m., where a Zoom link and associated call-in numbers will be provided on the town's calendar on the homepage at https://www.townhall.westwood.ma.us. Or if the Finance and Warrant Commission meeting is in person, the hearing will take place in the main library community meeting room at 660 High Street, Westwood, Massachusetts, beginning at 7 p.m.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Kate?
Aye.
Sean?
Aye.
Josh?
Aye.
Phil?
Aye.
I vote aye as well. Motion carries. The hearing is continued. All right. Let me just see. I don't believe we have any other business for the evening. Just a note about upcoming meetings. We have upcoming board meetings on May 6th, 2025, May 27th, 2025, and June 17th, 2025. And we have now continued that public hearing to the Finance and Warrant Commission article sponsors meeting on April 28th, 2025, and town meeting is May 19th. With that, if there is no other board business, I would invite the select board to adjourn their meeting unless they have any other board business, and then we can adjourn our meeting.
No, Rob, do you have anything else on the your agenda? Okay, before I accept the motion, I want to wish Phil a safe trip. And I'm sure I'm speaking for the other select board members as well. And I also wanted to note for the record that our town administrator, Chris Coleman, was in attendance for the entire meeting, but wasn't pulled in as a panelist due to some technical difficulties, but he was here throughout the meeting. I just want to get that in our minutes. So with that, I will take a motion. Mary Ann.
Sure. Thank you, Joe, and thank you to all of you. And with that, I will move to adjourn.
I will second both the thanks and the motion.
Roll call. Mary Ann.
Aye.
Rob.
Aye.
I vote aye as well. Motion carries.
Thank you,
you so
everybody.
much.
Thank
Thank
you.
you. All right. Then if there's no other planning board business, I would entertain a motion to adjourn.
So moved.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Kate,
Aye.
Sean,
Aye.
Phil,
Aye.
Josh.
Aye.
I vote aye as well. We are adjourned. Thank you, everyone. Phil, safe trip, and everybody enjoy the rest of their evening.
Thank you.
Take care.
Thank you.
Bye.